Good afternoon. I'm Simon Passfield and I'm the head of the Insolvency and Restructuring team at Guildhall Chambers. I'm delighted to be joined today by, on my left, Stefan Ramel, extremely experienced Insolvency and Restructuring counsel, and who, as we'll come to discover in a moment, has most recently acted successfully for HMRC in the Waldorf Production's Restructuring Plan case. On my right, Zachariah Pullar is the newest member of our team, having successfully completed his pupillage last Friday, and who will be taking us through in due course the three most recent Court of Appeal cases considering restructuring plans and the ramifications and implications of that for practice. Over the last 12 months or so, we've noticed a dramatic increase in restructuring work within Chambers as compared with more traditional insolvency work. As I've indicated, what we're going to be aiming to do in this webinar is to consider in some depth the recent trilogy of Court of Appeal cases, Adler, Thames Water and then Petrofac, and drill down on some of the practical consequences that arise from that. At the time we were planning this talk, we thought we'd be having to cast our net slightly in the dark and come up with some hypothetical examples of how these cases may work their way through in practice. But happily, in the interim period, Stefan successfully appeared in the Waldorf case, and so I'm delighted he's here on hand to give us some proper real-world practical examples of what happened from that case, and to the extent that he's able to, some ideas of where that may land in the future and possible further appeals. Now, for the purposes of this talk, we're going to assume that the audience will have reasonable familiarity with restructuring plans, but just by way of a very brief and simple overview, as you will all know, restructuring plans are a relatively new restructuring tool which were introduced by the Corporate Insolvency and Governance Act of 2020. The relevant statutory provisions can be found in Part 26A of the Companies Act 2006. Plans are available to companies which have encountered or are likely to encounter financial difficulties that are affecting or will affect their ability to carry on business as a going concern. They share many similarities with schemes of arrangement, but of course the key innovation of a plan, and part of the reason why they're most often used instead of, for example, a scheme or indeed administration, is the power of cross-class cram down, which gives the court discretion to impose a plan on a dissenting class or indeed dissenting classes of creditors if it's satisfied that they would be no worse off under the plan than they would in the relevant alternative. Now, the statute itself is fairly light in terms of any detailed indication of the approach that should be taken to the exercise of the discretion to sanction a plan. Deliberately, it's been left to the courts, therefore, to develop the proper approach. And most of the early High Court authorities concerning contested plans identified that the real issue usually when it comes to determining whether it's appropriate to sanction a plan where the jurisdictional requirements are otherwise made out is for the court to ask itself whether the plan involves a fair distribution of the so-called restructuring surplus. And I use that term advisedly because, as we'll come on to see, we've now been told by the Court of Appeal that that's a term that should not be used. But certainly in the early days, and in particular following the decision of Mr. Justice Snowden as he then was in Virgin Active, the working assumption was that when it comes to approaching the question of discretion, the court would usually not place any real weight on the views of creditors who would be out of the money in the relevant alternative and didn't have a genuine economic interest in the company. And as a result, certainly in the early plans, we customarily saw the situation where out-of-money creditors were given a token de minimis payment in consideration for compromising their rights. The justification being, well, it's better than you'd get in the relevant alternative, therefore you have no standing in effect to complain about this plan. And probably from the dissenting creditor side of the table, the high water mark was 2023, where we had two plans in quick succession, the Great Annual Savings case and the Naismith Group case with which I was involved, where the court refused to sanction plans in the face of opposition from HMRC. But certainly the prevailing view in the market up until early this year was that what those cases really did was to delineate the boundaries of what was permissible in terms of compromising the claims, in particular of the revenue under plans, And certainly the view was that we'd found a nice equilibrium where everyone was well aware of what the relevant principles were, how the court was likely to approach plans, and what sort of factors should be borne in mind when it came to preparing plans. That full storm perhaps sets the scene for what I'm going to turn to Zach to discuss now, which is Adler, which was the first time which the Court of Appeal had a chance to grapple with restructuring plans and get to grips with some of these propositions we find in the High Court cases, and in particular this crucial issue of how the court goes about exercising its discretion to cram down where you have a dissenting creditor who is out of the money in the relevant alternative, complaining this is not a fair plan and that there's an alternative way of doing it.
Thank you, Simon. So as Simon says, this is the first case of common law trilogy that takes up the issue of how to look at Part 26A. In some ways, this case was perhaps a straightforward case to consider this. It was a case where all the plan creditors were unsecured and they would all rank equally pari passu in the relevant alternative, which was a form of insolvency. So the plan here was envisaged to achieve a controlled wind down of the company. It wasn't envisaged that it would shore it up permanently. And it would achieve that by the injection of new money, as is usually the case, by the senior ranking creditors. They were called notes, to pay off some immediate liabilities falling due by the company, and by extending the maturity on other of those notes, which were the 2024 notes, which were the earliest maturing notes amongst the various classes of creditor that we're dealing with. And in return for that, amongst other things, the repayment of those notes, the 2024 notes, in return for the extended maturity on that debt, would be secured ahead of the other notes, and the creditors providing the new money would be issued shares in the parent Adler company, the Adler parent company, totaling 22.5% of the issued share capital. But importantly, as we'll come to later, the existing shareholders would retain their interest in the parent company. Now, the 2029 notes, so these were the note holders, the creditors whose debts matured the latest, they dissented on the basis that this plan departed pretty flagrantly from the pari passu distribution that would have applied in the relevant alternative, and that would therefore subject them to a far greater risk of non-payment than would the other notes whose debts would mature earlier, because the terms of this plan preserved that phased payment, that sequential payment, which of course would not obtain in a full insolvency, and that difference in treatment was not justified, and so that required the court to really consider, well, how do we look at how to exercise our discretion when we're looking at the cross-class cram-down power, and how to interrogate the fairness of these plans. So the Court of Appeal upheld that complaint on the valuation evidence by looking at the position of those creditors and how they would be treated relative to the other note holders versus how they would be treated in the relevant alternative. Now, there was also a contention which was kind of separate from those points, that those 29 note holders thought it would be quite unfair, further to those points, that the shareholders should be able to retain their interest in the parent company whilst they would be required to shoulder that greater risk.
Well, I think the essence of the point, wasn't it, was that the integral issue was that the in the money creditors were essentially saying, look, when it comes to a consideration of how you go about distributing the restructuring surplus, as it's then known, the courts should simply consider the relevant alternative. In the relevant alternative, someone who's out of the money gets nothing. and so therefore on that basis there's no need for them to be provided with anything within the restructuring plan, because effectively they're as well off, or in fact they're better off than they would have been under the plan, and therefore it's not really for them to seek to participate in any of the upside of the plan, or at least to put it another way, it's not unfair for us to allocate the restructuring surplus as between ourselves and in this instance some of the shareholders, because as a matter of principle, if you're out of the money in the relevant alternative, then effectively as long as you get a de minimis payment, it is what it is, which is basically a broad application, I think, of what Mr. Justice Snowden said in Virgin Active.
Yes. And there's a question mark over whether Adler perhaps should be seen as approving some of those dicta as to the weight to be attached to those views in the course of its consideration of this argument. And then when we come to Thames Water, we see that point is more closely interrogated and disposed of, albeit in the limited context of the plan that was being considered there.
I mean, for my money, I think there's two things that emerge from Adler in terms of the question of fairness on a restructuring plan. And there's an adjunct we'll touch on in a moment, which is a practical point which has not been heeded necessarily by the profession at large. The previous cases suggest that the exercise that the court undertakes when analysing the fairness of a plan is a binary exercise, and that what you do is you simply look at the plan, you look at the relevant alternative, and you make your assessment by reference to that. And certainly it had been suggested in some of the earlier cases that what you can't do, for example, is to consider a potential alternative fairer way in which the plan could be put together. And so the first key takeaway point from Adler is the Court of Appeal confirming that actually no, it is permissible for you to consider, is there a fairer way that this could be done? And so that aspect of the case might be seen to give some encouragement to dissenting creditors to try and concoct their own way of coming up with a different way of doing a plan. And I think, Stefan, certainly in your case of Waldorf, that was an issue that then...
Absolutely. I mean, as we'll come on to, that was one of the lines of attack which the opposing creditors took in Waldorf, putting to the court that the relevant alternative wasn't what the Plan Co had suggested it was, but was some other form of plan. And I suppose the interesting point, Simon, which flows from what you're saying, is the extent to which, in the absence of assistance from an unsecured creditor or an opposing creditor, the court can go on its own frolic, if you like, in trying to find out what a fairer way of doing it might be.
Which is quite an esoteric question. But I think the big point that I take away from Adler is that actually, despite what has been said in later cases, and I know you'd be careful what you can say about that, Stefan, given that Mr. Justice Hilliard may have formed a different view in your case, I don't read Adler, and I don't think anyone at the time read Adler, as suggesting in any way that Virgin Active was wrong. If anything, it seemed to endorse the Virgin Active approach, because you have, in Adler, the argument being run by the dissenting creditors is this plan is unfair because we effectively create the surplus value for the company because the debts that would be otherwise payable to us straight away fall away, or the maturity date pushed back. And the people who get the benefit of that are a combination of the secured lenders who are acquiring this enhanced share in the company under the plan, but the existing shareholders because they retain some economic benefit. And that actually, how can that be fair? Because go to straightforward principles of insolvency law, you have a pecking order, and it goes secure creditors, and it goes unsecured creditors, and then it goes shareholders. So how can it be fair that you have an insolvent company that's restored to solvency, the shareholders get some benefit, and the unsecured creditors effectively create that by having their debts taken off them? And so the argument was the court ought to manufacture a situation in which effectively you expropriate the shares from the shareholders. And the ratio of the case in this respect is simply that there's no power to expropriate shares. But it's the throwaway comments from Lord Justice Snowden as he was then, that I find particularly interesting, where he says, well, really what you're saying, out of the money creditors, is that maybe the secured lenders have missed a trick because they could have negotiated for a greater share. And so that seemed to suggest that actually the takeaway from Adler was it gives encouragement to the secured lenders to push for an even more of a slice of the pie, but not that it allows out of the money creditors to complain about not having themselves shared in the plan. The other point I just mentioned in passing, which is the practical point, or two practical points, is that in the judgment itself, Lord Justice Snowden laid down a pretty clear marker that plan companies should not expect the indulgence of the court if they come in a great terrible rush to court saying we need to have a meeting taking place tomorrow, we need to have the sanction hearing the following day, there's not going to be enough time to provide disclosure to all the creditors, but it is what it is because this is a really urgent case. And whilst he acknowledged that there are certainly some cases where you do need to get into court quickly, in a case like Adler, where actually there was no proper pressing urgency, there was a firm warning laid down to parties to make sure that you enable there to be a proper information sharing process and sufficient time for the court to not only consider the plan, but also to consider time for giving judgment and potentially an application for permission to appeal. As we'll come on to see, that's a health warning that wasn't then heeded in Thames Water. And so we see, in a moment we'll see when we discuss that, the court reiterating that point. But it's worth just bearing in mind that the court would expect the plan companies to bake into the timetable sufficient time to deal with those matters. The other practical point is, again, an expression of surprise from the Court of Appeal as to how the plan company went about approaching the appeal. Also, rather, the appellant, went about approaching the appeal. What happened in Adler is that you have the judge on the 12th of April of 23 tells the parties he's going to sanction the plan, and he makes an order sanctioning the plan but then adjourning off all consequential matters to a further hearing. In the usual fashion, then written judgment is circulated to the parties. That is formally handed down on the 21st of April. You have a consequentials hearing 4 days later on the 25th of April. And then the disgruntled creditors wait until the 21 days have elapsed, or practically elapsed from that hearing, to then put in their application for permission to appeal. In the meantime, what they don't do is apply for a stay, ask the court to defer notifying the registrar of companies of the order pending a potential appeal. And that's obviously creates difficulties in the event, as happened in this case, that you have a plan that's approved by the High Court. There's then an appeal where that decision's overturned, but in the meantime, all the parties have acted as if the plan has been approved. Lenders put in more funding, creditors' claims are treated as having been compromised, money's paid out, and then it has to be unwound. And so again, there's a clear steer from the case that really parties ought to be thinking about permission to appeal pretty much from the get-go, and if they anticipate appealing, they ought to be inviting the court to delay implementing the consequences of the plan so far as possible to enable a meaningful appeal to take place. But certainly anyway then, so post-Adler, we've been to the Court of Appeal. It seems that what the Court of Appeal has said is we're endorsing Virgin Active, or at least that's the outward appearance of the profession. As I say, we'll come on to in a moment. Certainly in your case, Stefan, Mr Justice Hildyard suggested that's not what Adler says. And on a close reading, one can see how he gets there. But certainly, when then the plan in Thames Water goes to the Court of Appeal, I think perhaps it's fair to say it was a surprise that the Court of Appeal seems to have changed the approach quite dramatically, Zach.
Yes. So just to give a brief overview of this case, I'm sure everyone knows about it, very high profile of course. But the plan there had the unique feature of being an interim temporary measure to extend the liquidity runway that Thames Water had, so that it could achieve some permanent restructuring or substantive restructuring within 6 months. Otherwise it would be facing a special administration. And it achieved this, or sought to achieve this, by extending the maturity, the maturation of its Class A and its Class B debt, so the Class A and Class B creditors, as well as from the introduction of new money in the form of the super senior funding, which the Class A and Class B creditors had equal opportunity to participate. Now, the basis on which the Class B creditors, there were some other small, more junior creditors that also objected, but I'll just be focusing on what the Class B creditors said. They took issue with the terms on which that new money was to be made available. It was said to confer certain valuable rights on those creditors, the Class A creditors, the most senior creditors that were not available to the more junior creditors, and of course the cost of the plan, which I think the judge at first instance described as eye-watering, and they did give him substantial pause. But the Court of Appeal nevertheless upheld the sanction, but in passing, as Simon's just alluded to, dealt with this issue, which the judge dealt with at first instance quite differently, as to whether these Class B creditors who it was found on the evidence would be out of the money, so they'd have no genuine economic interest in the event of a special administration, whether their views ought to be given any weight. And indeed, the submission that was accepted below, I think by Mr. Justice Leach, was that the court simply had no obligation to consider whether the allocation of the benefits of the restructuring was fair from their perspective at all. They simply were to be discounted if they're out of the money, as the plenary creditors were here. And so the Court of Appeal says, well, forgive me, but that's not quite right. First of all, it deals with this issue, again dealt with by the judge differently below. Was there any restructuring surplus in this case? We're dealing only with an interim plan. And that's where we get a rejection of this language. Yes, it didn't generate any quantifiable financial benefit for the creditors, but it did give the company, for the benefit of the creditors as a whole, a really crucial advantage. It bought them some time in order that they could carry out further negotiations to achieve this permanent restructuring. And so once you've kind of got this more capacious understanding of benefit, that then allows the interests of these out-of-the-money creditors to be brought more fully into account. And so on that point, the court rejected, insofar as this is what Virgin Active held, that the views of the out-of-the-money creditors ought to be given no weight. And this point of principle perhaps comes through most clearly. It's paragraph 149, where it acknowledges that it might be appropriate, if they're out of the money, that they should not be able to benefit from the surplus, as we might call it or might not call it, but also that different plans take different forms, have different purposes, and that it might in other cases be appropriate to bring them into account, indeed obligatory on the fairness test adumbrated by Adler to do so. And so in Thames Water, a really clear example of this perhaps is where the creation of the benefits of the restructuring that we've been talking about in buying Thames Water time depended on the release by the Class B creditors as well as the Class A creditors, but the Class B creditors of their rights against the company to extend the maturity on their debt so as to enable this interim measure properly to be implemented. And so both sets of creditors contributed equally to that. It's really perhaps the same point as when one provides new money. It's the two sides of the same coin. Both are necessary but of course, depending on the terms of the plan you're dealing with, both are necessary to the success of the plan that we're talking about and the achievement of the benefits that result from that.
I mean, I think it's fair to say that Thames Water opens the door to out-of-the-money creditors to mount challenges against restructuring plans on a discretionary fairness basis. Yes. But it didn't go as far in that case, for example, to successfully uphold such a challenge. And I mean, it is a sea change. I think that let's make no bones about it. It is a fundamental rejection of the Virgin Active approach as being too narrow in scope, and that there's a broad distinction between the no worse off test, where you're looking to see whether or not a particular class of creditors is being treated less favourably than they would in the relevant alternative, because it's only if you're satisfied that they're no worse off under the plan you even get into the jurisdiction to consider sanctioning. But then the slightly more esoteric question of fairness, which is perhaps slightly more nebulous, as we'll come on to see in a moment when we discuss Stefan's case, but that whereas the bright line seemed to be before Thames Water, well, really any benefits that are created by the restructuring are to be shared by those who would have benefited by the relevant alternative, because once you're out of the money, you're out of the money. As you say, Zach, there seems to be more of a recognition of the fact that in most cases, in order for you to achieve the state that the plan's intending to achieve, whereby the company usually is restored to solvency or at least is able to carry on, you're going to have a combination of factors. One is going to be provision of new lending, probably, because that's usually going to be inevitable. The company needs that pipeline of funding to continue trading forward. But also it's going to involve some creditors giving up rights, and that by doing that you've created this, we can't call it restructuring surplus anymore, but we know what that term means. And so that I think really is revolutionary, and you can see where it then opens up the door to arguments that can be run by those out of the money to try and engineer a better commercial situation for themselves. And as we'll see in a moment, I think Petrofac then takes that door that's ajar and firmly opens it widely up. But the only other thing I would just stress when we're talking about Thames Water, again, is it contains very early on in the judgment, in fact it's paragraph 3, another ticking off of the plan company, and the language of the Chancellor is that it was unacceptable that the first instance judge was put under enormous pressure to hear the case and hand down judgment in a compressed fashion. And he then proceeds to quote verbatim what was said by Lord Justice Snowden in Adler. And whilst there don't yet appear to be any examples of the court having failed to consider the sanctioning of a plan in case of genuine urgency because of the manner in which the company went about approaching the court, and certainly there's not been a case where the court so far has allowed a company to collapse because of its conduct. The mood music is there, and so you would not want to be the first case in which that happens, where you're told by the court, sorry, yes, your plan may well have been viable, but you haven't given sufficient disclosure to the creditors, that's unacceptable. We don't have the capacity to hear you, and so you have to pick up the pieces as and when we can finally get to court. So that's worth bearing in mind. But now, I think, Zach, we can turn to the third of the cases in the trilogy, Petrofac, which, as I say, has more broadly opened up the door to out-of-money creditors and challenging plans.
Yes,
Simon, Zach, before you go on, just to add very briefly,
Please.
Simon, to your highlighting the practical warnings given in both Adler and in Thames Water. It's not to be forgotten that as from next year we'll have the new practice statements on plans and schemes, which, although probably not going to revolutionise how these are put together and the lead up to the convening and sanction hearings, may change the dynamic slightly. So it's very much a case I would have thought of watch this space.
Yes. And I suppose the only other thing to note is that in the first few years of Part 26A, when plans are in their infancy, there were relatively few and far between, and it was a lot easier, I think, to find a High Court judge whose diary could be booked out for a sufficient period of time, and the courts were quite enthusiastic to ensure that they got it right and they were accommodating the parties. As we're now seeing more and more plans, there's still only a finite number of judges, there's still only a finite number of sitting days, and I know there's some suggestion that it may be possible to allow the ICC judges to hear more straightforward plans to unlock that. But a lot of the plans we've seen in the cases so far can't be described by any stretch of the means as straightforward, nor could they be described as at proportionate cost, I think, in most cases. So there's always going to be a bit, particularly in the big cases, a bit of a competition for finding that court time, and anything and everything can be done to ensure that that isn't abused, the better, because at some point the feeling is that there will be a case that comes along where a judge may well turn around and say, I'm going to make you the example for everyone else.
And it's certainly a point which I'm sure opposing creditors would be alive to, and it's a point they might take. But anyway, having jumped in with that observation, Zach.
So, as has been trailed, Petrofac, unlike Thames Water, was again a case that was concerned with a full-blooded restructuring, a full-blooded balance sheet restructuring, and so gave the Court of Appeal the opportunity, if it sought to take it up, to look at the door opened ajar by Thames Water and to open it fully, and I think that's what we do see here. So just briefly on what we're talking about. So as I said, it was a full-blooded balance sheet restructuring, wiping away all the debts to have a clean slate. And that the achievement of those objectives, or to further those objectives, achieved by the injection again of new money by the plan company's most senior creditors, and that was in return for the allocation of equity totaling some 67.7%, which is worth some 1 billion in the post-restructure group. And Samsung and Saipem, who are the two objecting creditors, they took issue with this on the basis that the benefits of the restructuring, in particular the allocation of the benefits to the providers of the new money that I've just spoken about, that was those benefits were allocated disproportionately to them and not to the unsecured creditors, who again were required at least to give up some of their claims or to suspend some of their claims in order for this restructure to be carried out. So before we get on to the issue of fairness squarely, the court deals first of all with the first ground of appeal relating to the analysis of the no worse off decision. So this comparison. And in particular as to whether these two creditors, Samsung and Saipem, who were direct competitors of Petrofac, whether the fact that if that they were bound to this plan, they would lose a market advantage that they would obtain if Petrofac folded, because they could take up all the market opportunities that Petrofac was using. And so there's an issue about whether that was to be brought into account when you're making this comparison between the position of those creditors under the plan and in the relevant alternative. And I think at first instance there was a recognition that might be appropriate, but that there's an issue as to drawing the appropriate boundary lines around that, turning perhaps on a slightly nebulous concept of remoteness. But here we have the Court of Appeal quite carefully drawing tightly those parameters. It depends on what are the rights of the creditor that are compromised or arranged by the plan vis-a-vis the company primarily, but possibly against third parties. And if those indirect economic consequences that might follow from the plan being implemented, as far as they should be brought into account at all, they're relevant only to the issue of discretion, which raises a question, I think.
Well, it does, doesn't it? Because, I mean, pausing there, so what you have in that case is a pretty brave submission, don't you? Which is, well, we are left worse off as a result of this plan because if our major competitor falls into insolvency, we'll have this commercial advantage. And it seems pretty self-evident, intuitive stuff that can't be something brought into account in the no worse off test. But then by the court saying it could be brought into line at the discretion stage, that seems to beg a question that doesn't really have an answer, because I struggle to see a case in which a judge would legitimately say, I'm satisfied that this dissenting creditor who's voted against the plan is actually no worse off under the plan than they would be the amendment alternative as regards their actual rights as creditor. I however, consider that it would not be fair to sanction this plan and allow this company to continue, because by doing so I deny them the ability to have this competitive advantage, because notions of fairness more broadly when we look at the cases tend to be fairness as between creditors qua creditor, which seems a bit different from saying, flip it on its head, it would be a brave judge, I think, wouldn't it, who says, I really think ultimately I should allow this company to fail because I want to ensure that Samsung in this instance can be even more successful a company than it otherwise would previously be. So although the case raises the spectre of these sorts of issues coming in discretion, I certainly would struggle to see how they would actually, in practice, in a real life case, although of course that's not to say there might not be one that comes along at some point and there might not be some tangential benefit that we haven't foreseen yet that could be a reason for not approving a plan, but it would have to be a pretty unusual case, I think.
Yes, quite. The analysis is not aimed at some sort of freestanding fairness analysis, is it? It's squarely about whether the distribution of the benefits of the restructuring are fair, and it might be difficult in some of these cases, for example, a loss of competitive advantage, how that has anything to do with the benefits generated or preserved by the restructuring, as opposed to something entirely collateral and unrelated to that. Just turning more pertinently to the issue of fairness that we are talking about in the thread that we're following through in all these cases. As I mentioned a moment ago, the argument was that essentially the terms on which the new money was being provided was at some extreme cost, disproportionate cost, and that therefore amounted to not the cost of the restructuring, really, but moved into the territory of the benefits of the restructuring as opposed to the cost thereof. And that requires properly to be analysed, and the judge didn't do that. Or the judge below said, these creditors and or other investors face significant risk when they put in this money, and that justifies the level of return they have. But as the court points out, there was a little bit perhaps of a misanalysis there, because we're talking about investment into the post-restructure group, not the pre-restructure group, and there was no evidence of any analysis of what market terms that sort of investment might be available, and therefore whether that was properly seen as a cost of the restructuring or an allocation of the benefits thereof. And since that question was never addressed, the issue of fairness in that allocation was never properly analysed, and so that sort of vitiated the exercise of discretion by the judge there. I don't know if you want to take that up, Simon.
Well, there's a certain logic, isn't there, to the court's analysis, because as we mentioned earlier, in most cases where you're contemplating a restructuring plan, there's going to be effectively two sources of input that creates the benefit. There's going to be the removal of problematic debt, or at least compromising or otherwise restructuring that debt. And there's usually going to have to be some injection of further funds, because if the company's facing financial difficulty, there's almost certainly going to be a liquidity issue. And one can perfectly understand that if that funding comes in from genuine third-party, unconnected parties, independently of the company, negotiated in the marketplace, then that is just simply a cost of the restructuring. You can't do the restructuring without that money. You need to get that money. It costs a certain amount. That's the cost of doing it. And as the Court of Appeal says, if it so happens that the people putting in that new money are not independent third parties, but pre-existing secured creditors, but you can show that actually, in fact, the amount they're being paid is the market rate, then again, there's no issue there, because that is just the cost. You'd have to pay someone else to get that cost. The fact it's existing creditors you're paying is neither here nor there. The problem becomes more visceral when that secured lender says, I don't just want to recover effectively what would be the market value of the new lending, but I want to elevate some of my existing debt so that is given super priority, and I want to therefore be paid more than I proportionally otherwise would. And one can understand there will be cases in which that's perfectly permissible, because there may well be cases where there is no one else willing to lend. They are the only people who are willing to lend. They will only do so on those enhanced terms, and provided the company can show they've jumped through the hoops of approaching other people, they've engaged in proper commercial negotiation. They've invited other creditors to participate and potentially lend on those terms. Then, of course, there's no issue or no fairness issue with the company saying, look, we have to pay these people this amount of money as a condition of securing the funding to allow us to continue. In exactly the same way as they might say, there are certain categories of unsecured creditors we are choosing to treat as not part of the plan because they are the supplier of the widgets we require to manufacture our products, or whatever the case may be. They are the employees without whom we cannot continue to trade. The problem comes, though, where there's no obvious evidence that that is what's happened, and that the secured lender is just using the threat of pulling up stumps and their ability to put in new money as a means to extract more than proportionate value out of the company. And one can understand why, until now, it may have been thought that that is just how a plan works, because that's basically what Virgin Active effectively says, which is, well, if creditors are out of the money, then it's no matter for them what happens to any benefits generated by the restructuring. And if it so happens that it's agreed that the secured lender is going to get them because they're going to acquire new equity, what the case may be, so be it. But the trouble is we're now living in a post-Thames Water, post-Petrofac world. And as Stefan will come on to talk about now, no doubt, we're having cases butting up against that where plans were prepared in that prior to that world, and it came as a bit of surprise perhaps to the companies when the court then says, well, I'm sorry, but that's not how you go about doing a plan, and you've therefore proceeded on a false premise. But that's a convenient juncture, Stefan, for you to
absolutely
talk us through Waldorf.
Waldorf was decided in the wake of the Court of Appeal in Thames Water and Petrofac, but the plan was launched before both of those Court of Appeal decisions. The PSL in Waldorf was February, Thames Water was April. We then had the sanction hearing in Waldorf in June, and the Petrofac judgment was on the 1st of July. So of course after the sanction hearing, but the parties were given the possibility of making written submissions on the effect of Petrofac. So although the parties had a chance to deal with Thames Water and Petrofac, they were doing so against the backdrop of a plan which had been designed before both of those Court of Appeal cases. Now, as is well known, and as Simon has hinted at, Mr Justice Hildyard refused to sanction Waldorf's plan, and it's a case in which I acted for HMRC, which was one of two opposing creditors. And really this is the story of the case so far. So what I was going to do is run through some of the background facts and then identify the key parts of the plan before looking at what the opposing creditor said and then finally what the judge said. And from the benefit of my experience of appearing in that case, I was going to touch on a few thoughts that I had and some takeaways which no doubt we can discuss. One rider to everything that I'm about to say is that the story in Waldorf is not necessarily yet over, because I'm sure it's well known. On the 9th of September, so a few weeks ago, Mr Justice Hildyard acceded to the plan company's application for a leapfrog certificate to enable it to appeal to the Supreme Court. So all I can really say is watch this space.
Although, just to be clear, that doesn't mean they've got permission to go to the Supreme Court, does it? It means that they're allowed to ask for permission.
Absolutely, they're allowed to ask for permission. And in fact, the Petrofac Court of Appeal decision was also going to be appealed to the Supreme Court. But again, as is well known now, that was compromised. So in Waldorf, the highlights, the facts, the company itself, Waldorf Production UK PLC, Planco WP UK, was in a group. The group was engaged in exploration and production of oil and gas on the UK continental shelf. And its main asset, the jewel in its crown really, was licence interest that it had in UK SC fields. And in fact, some of those have been acquired from a company then called Capricorn North Sea Limited. And we'll see that Capricorn comes up again in the story in a moment. A key factual element of this case is the introduction in May 2022 of the windfall tax. And so this was in response to extraordinary profits being made in the oil and gas sector. And what it did was to impose an additional 25% levy on profit. And whilst it had an original December 25 sunset, that's been pushed back and indeed the levy has been gradually increased over time. So by November of 22 it was already 35%. Now, EPL is payable at the same time as corporation tax, so 9 months and a day after the relevant year end. The next stopping point in the factual story is the dividend. So in October 2022, after the introduction of EPL, the plan code declared a $76 million dividend, and that was paid up the chain, including to individual directors who at the time were directors of Planco. Now that dividend was declared by reference to management accounts, and they showed purportedly substantial profits available, $250 million, and it transpired, in fact, as a result of questions and pressure put by the opposing creditors in the context of the plan, that those management accounts were wrong in several respects, including in relation to EPL, and in fact the 2020 audited accounts for the company showed a negative figure of some $362 million for distributable reserves. So saying no more than, there were big question marks over this dividend. Matters came to a head in May 2024, May last year, when the plan company was notified that a receivable discounting facility was going to be withdrawn. And that was followed by the administration of two parent companies in June 2024. And the administrators of those companies then ran a sale process which took about 6 months to see if they could generate any offers for the shares in Planco, but no implementable offers were received. Hot on the heels of that was a refinancing, and I'll describe the creditor structure in a moment, but the refinancing involved secured bonds being held by, or issued, by WP UK, some of which were held by Steerco, or members of a Steerco of bondholders, who then refinanced those in July. That had the effect of extending maturity dates, some amortization payments were deferred, and then somewhat euphemistically, there was what was called a roll-up on a cashless basis of some other group company bonds. And what the judge said in far more plain English is that what this did was to swap bonds issued by other group companies so that they were now treated as issued by WP UK, which led to an increase in the bondholder constituency from $52 million to $108 million. At that point, there was some new money. Moving on in the story, by November of last year, there was an intragroup loan where $15 million was lent to another company to enable it to make critical payments. Some of that had been repaid. And then we had the PSL in February. Now, the plan company's evidence before the court was that some form of restructuring had been in contemplation since the summer of 2024. So the backdrop then to the terms of the plan is that some sort of plan was going to be necessary, potentially from the summer of 2024, depending on how the sales process went. The plan company's evidence was that by December 2024, matters had come to a head. There'd been no sale, and then from then until February 2025, there were what were described as accelerated discussions between two bodies, plan company on the one hand and Steerco to formulate the plan. As will become clear, there were no discussions with any of the unsecured creditors. So the plan, which was launched in February 2025, had two key constituencies of creditors. The bonds, so that was made up of original bonds, super senior bonds. They were secured creditors, and the total value, as at the date of the PSL of those bonds, was approximately $110 million. And then the second constituency was the unsecured creditors. And here it was HMRC, and HMRC were owed approximately $75 million in respect of unpaid EPL. And that was covering 3 tax years, 22, 23 and 24. And then also there was a separate liability to another unsecured creditor, which was a Capricorn entity, which was owed approximately $29 million following a settlement agreement arising out of the sale that I've mentioned already of a Capricorn entity. There were other creditors, for example, substantial intercompany liabilities, but they weren't material in terms of the judgment on this plan. Now, the proposal was that the bondholders would have the maturity date of their bonds extended until 2027. They would keep interest at 13%. There was a tweak to a liquidity covenant. There was an excess cash mechanism, whereas if in circumstances where WPK had surplus cash, that would go to the bondholders, and potential new money of up to $10 million. So far as the unsecured creditors, what was proposed was that their liability would be entirely compromised in return for a cash payment of 5% of their liabilities and the ability to participate in an upside sharing agreement.
And that was presumably so far so standard at the time.
As you say, so far so standard. I hesitate to describe it as vanilla, but not an unusual plan. In terms of what the end game of this plan was, the extension of the maturity date for the bondholders and the additional potential new money clearly was with a view to enabling a sale of WP UK on terms which would be more advantageous than the sale exercise which the administrators had attempted to run. So far as the plan company was concerned, they said the relevant alternative is either a distributing liquidation or administration. The bondholders, of course, voted in favour. The unsecured creditors voted against. This then brings me to the arguments which HMRC and Capricorn ran, and there were broadly two categories. The first was the relevant alternative wasn't an administration or liquidation, but it was some form of alternative plan. And then the second tier of argument was that as a matter of discretion or fairness, the plan shouldn't be sanctioned. And that latter argument focused on the lack of negotiations, challenged the plan company's evidence in relation to liquidity, some general points about the dividend, the refinancing and the professional fees. What wasn't challenged was that condition B in section 901G was satisfied, and of course there was an argument on the basis of the relevant alternative not being liquidation that condition A was not satisfied. HMRC also put forward a more overarching point, which was that this plan was an abuse of process, and going back to first principles of civil procedural law, in other words, it was using the court process for a purpose or in a way which was significantly different from the ordinary proper use of the court process. One final point on the arguments. Although the unsecured creditors, the opposing creditors, had permission to put in expert evidence, as it happens, they didn't in this case. So far as the judge's judgment, he started by assessing the arguments around relevant alternative. What the unsecured creditors had done, working jointly, is that they'd made joint offers to the plan company, and in effect the bondholders. First of all, they said, well, we will accept 20% rather than 5%, and that then came down to 15%. Those approaches were rejected, principally on grounds of affordability. Capricorn also challenged the suggestion that the bondholders would allow this company to go into an insolvency process in circumstances where, if that were to happen, the bondholders would do worse than accepting one of the offers which had been put forward by the unsecured creditors.
That sounds very reminiscent of an argument I ran unsuccessfully in the Naismith Group case.
And this argument in this case was also unsuccessful because ultimately Mr. Justice Hildyard found that he couldn't gainsay what he was being told by the CEO and one of the members of Steerco. There's also some useful tidbits in there about any form of alternative restructuring or plan has to be sufficiently definitive that the court could apply the relevant statutory mechanisms to it. So is the no worse off test met, and so on. And his view was
that's always quite difficult when you're acting for a dissenting creditor without all the information and financials to be able to put together a plan in the first place.
Absolutely, and as I'll come on to say in a moment, one of the takeaways for me from this case, and we'll have to see how things shake down with the new practice statement, is the information asymmetry between the plan company, which of course has all the information, and the unsecured creditors or opposing creditors who may not.
That may go back full circle to the health warning about giving them sufficient time with the information as well. It's not just asymmetry of information, it's
the time to obtain it before a cliff edge
yes.
comes to pass. Yeah. Now, of course, hindsight's a wonderful thing. No cliff edge was put forward in the Waldorf case, and it's fair to say that we're now in the middle of September, and so far as I'm aware, WPUK is not in any insolvency process at this stage.
But I thought you said they were going to put the company into immediate insolvency if the plan wasn't approved.
Well, that may or may not have been their evidence, but anyway, for the purposes of the judgment, Mr. Justice Hildyard accepted that the relevant alternative was what the plan company said. That then brings us to fairness and discretion, and here the judge did analyse the trilogy of cases, and his focus, and I suppose what he took away from them, was that negotiations in the lead up to the plan were important, as is identifying the restructuring benefit. He also worked on the basis that just because HMRC and Capricorn was said to be out of the money didn't mean that one could simply ignore their position. So far as the genesis of the plan, he found that there were no negotiations at all with HMRC or with Capricorn, and in a sense worse than that, and as arising out of cross-examination of the CEO, which I did, which I understand I was told is the first time HMRC have cross-examined parties in a plan case. Mr Justice Hildyard also found that provision hadn't been made by the plan company for the Timaeus payments of EPL, and moreover that it didn't intend to disclose the prospect of a plan until after it had been announced. So it's one can think of it this way: whilst the company was putting in place a restructuring plan, it was continuing to accrue liabilities which it didn't intend to pay because it intended to cram them down in a plan. It's fair to say, and this is apparent from the judgment, that the plan company's management did get in touch with HMRC about the 2022 EPL, but they did that in June 24, so sometime after it was first due. Administrators had been appointed already to the hire companies, and even though there was engagement on the 2022 EPL, there hadn't been any engagement in respect of 23 and 24. Now, obviously that begs the question why, and the plan company's evidence was, well, there's no point, and it's pointless anyway, because HMRC wouldn't agree to a write-down of its debts, at best a time to pay, and the CEO said, well, that would be futile. But, and this is an important point, which feeds into one of the takeaways that I have from this case, is that assertion wasn't really supported by any form of detailed company data, whether cash flow forecasts or management accounts. In due course, the judge was very critical of the approach, and he said this. He said that it was the antithesis of the fair dealing to be expected of a company seeking to enlist the assistance of the court in cramming down a dissenting creditor. That then left the benefits of the restructuring, and here the judge said, well, that's for the plan company to prove. It's for the plan company to prove how it's fair, and his view was that the benefits of the restructuring in Waldorf were fairly easy to articulate. He said prior to the plan, the valuation evidence was the company had a negative value of some 83.3 million. Immediately upon sanction, the plan company would have a positive value of some 18.3 million. And Mr Justice Hildyard said, well, that swing, the difference between the two, is attributable purely to the fact that HMRC and Capricorn's liabilities would be extinguished. And so there was a substantial benefit to the plan company in the plan being successful. The bondholders, his view was, were not really contributing anything. And so this then leads to the question, if one is looking at two different worlds, which is the relevant alternative world and then the plan world, the outcome is very different for if one looks at it through the lens of giving up those liabilities. So he said, well, if it's the opposing creditors who are giving up all their liabilities, and that's the benefit of the restructuring, how is that benefit going to be shared between the two creditor constituencies? Now this then brings us to what ultimately has to be the more complicated part, which is, and one that Mr Justice Hildyard raised during the hearing, which is how one fixes a number, a payment, a percentage, whatever it might be. It was very clear that simply looking at the position in the relevant alternative is not enough, and it's not enough to say, well, in the relevant alternative you're out of the money, so we'll give you a few more percentage points, and that makes the plan fair. And in fact, in cross-examination, it became very clear that the 5% figure, that there was really no science behind it at all. It was essentially an arbitrary figure which the steerco could live with. And that meant that one has to look, so said Mr Justice Hildyard, at the negotiations. And his snippet really on this was that the pattern and results of the previous negotiations between the plan company and the relevant class is likely to offer a useful perspective in terms of the upper limits of the expectations of the dissenting class, that is, but also in providing a useful insight into whether the dissenting class has negotiated fairly and reasonably, or whether in reality it's just trying to extract too much out of its veto position. The judge also didn't accept that the arguments that 5% was all that could be afforded were supported by the evidence. He relied on the fact there was no cash flow or liquidity forecast, And his view, and again, this really, I suppose, drives home the fact that there are two different lenses through which one looks at this, is that all of the plan company's evidence faced the wrong way, because it looked at what would happen in the relevant alternative as opposed to looking at what was going to happen in the plan. And so ultimately his conclusion was that the plan company hadn't discharged the burden of establishing a fair allocation of that benefit. And so he didn't need to go on to consider the points about dividend and the July refinancing. So in terms of some points to take away from that, and I'd welcome both your thoughts. So for me, an important point is going to be negotiations, early engagement. From a plan company's perspective, it seems as though now the mood music from the court is that the court was going to expect to be able to see what steps have been taken with creditor groups. And obviously from an opposing creditor perspective, or a potential opposing creditor perspective, they will have to demonstrate engagement. And engagement isn't going to be enough, is it? It's got to be rational, well thought out, because if you're an opposing creditor, you don't want to fall into the category of just holding out and vetoing. So there has to be some logic and rationale to the position which is adopted. This also means, Simon, the point that you were raising is in terms of the information disparity between the company which has the cards and the opposing creditors which don't have the cards. There will have to be some form of information sharing, and I suppose there will be interesting discussions to be had between planned companies and future creditors as to how that information is shared. Is it treated as confidential, and so on. But for me, that's good. That's one key takeaway. So there's going to have to be a focus on that.
Well, I mean, that's a point that goes right back to Virgin Active, doesn't it? Where you had the ad hoc landlords in that case saying, we want to be provided with the information upon which you based your assumptions and your plan.
Yeah.
The plan company tries to resist that, saying this is commercially sensitive information. And even then, in the pre-Thames Water Petrofac world, the court's still alive to the fact that to analyse it properly, you need to provide the information and needs to be the proper confidentiality undertakings in place. But the difference there was that was very much a case of those creditors who were shouting loudly had the onus on them to go and try and encourage the company to provide them information and offer up the undertakings.
Absolutely.
Whereas now it seems much more like the emphasis is on the company to say to all creditors
Yeah.
at an early stage, we're in financial difficulty, we envisage the way through is doing a plan. In broad outline terms, this is the plan we're proposing.
Yeah.
What do you need to see from us
Absolutely.
to persuade you that that is where we are financially, and that this is what we're proposing as a fair allocation, and this is why we say this is fair. And I think it's probably right to say that a lot of the cases that from sort of 2020 to 2024 where plans were sanctioned, many of them may not now have been approved.
It's entirely possible. And I suppose a corollary of what we're talking about here, the negotiations, I suppose it has to be against some form of backdrop. And this now is going to involve not just the relevant alternative, and clearly both sides will want to scrutinise that, but also the early identification, not quite front and centre, but it's going to be important to reflect on this, is that in the plan world, what are going to be the benefits of the restructuring? And of course that's going to start with very basic questions such as what sort of plan is it, but it's inevitably going to look at who's giving what, who's giving up what rights, is new money going in, and so on. And then that leads into, for me, the third point here, which is in Waldorf there was a burden of proof issue. That means whether you look at it from a plan company perspective or from the opposing creditor perspective, clearly the plan company's evidence is going to require very careful drafting and scrutiny through two lenses, the relevant alternative lens and demonstrating whether or not opposing creditors or other creditors might be worse off, but also looking at the position in the plan world where the plan is successfully implemented and what the position for the creditors is going to be there. So not just satisfying the statutory test, if you like, but also anticipating the opposition arguments. And the obvious things are always insolvency, liquidity, out of the money creditors, and those are matters which have to be covered off in evidence, and it's matters that really the opposing creditors should be considering.
I mean, there's another slightly more commercial point to all this as well, isn't there, which is that certainly my experience prior to the Court of Appeal was there's often instances where it was in the commercial interests of a particular creditor to say to a plan company, well, look, you could spend quite a lot of money and a lot of time trying to get this plan through, and you might succeed in cramming me down, but you might not. And I can make all these sorts of arguments that might excite lots of other creditors in the same class as me. But if it just so happened that there was another company in your group that happen to want to chuck me a sum of money, completely ex gratia, outside the plan,
Yeah.
then it may well be that I decide that I can live with what I get under the plan, and I will therefore not oppose. In fact, I will vote in favour. I won't take any of these points. I won't ask for information, etc., etc. And it seems that that probably is still the case now. That it might, in light and self-interest of some creditors, it may be for them better to take that sort of, I'm going to shout loudly and you buy me off. Because there is even more a risk they would successfully be able to blow up the plan.
Well, I suppose the only thought which comes to mind there, and thinking about it from the plan company's perspective, that there is a risk there, isn't there? That's if you're treating one creditor constituency differently by, in effect, buying them off, whether that is then going to mean that other creditors will be able to say, well, hang on a moment, when looking at overall fairness, that's something which is to be taken into account, because you're teaching different creditors differently. But absolutely, I agree that an opposing creditor might have commercial considerations very much to the fore. But so far as the court is going to be concerned and looking at whether to sanction a plan and fairness, any negotiations or communications really have to be through a lens of challenging what the plan company has proposed in terms of the allocation of the benefits of the restructuring. That final point is strategies for opposing creditors, and for me here the highlights are there's normally, in my experience, a voluminous amount of material which is generated by a plan company, and it's really necessary to dissect that as quickly as possible and focus on what are going to be the key areas. So insolvency, the cliff edge, the relevant alternative, and valuation and benefits, and that's really got to be the primary focus. And it's for opposing creditors or creditors who might be caught up in a plan really to take an early view whether or not they're likely to oppose, likely to support, and if they're likely to oppose, to start taking steps at an early stage in order to raise issues and challenge the evidence, or the material which is coming out of the plan company. Now, Waldorf is a case where there was actually quite a long gap between the convening hearing and then the sanction hearing. But as you've alluded to, Simon, sometimes in plans there's far more urgency, and so it's necessary for opposing creditors to sort of get up to speed and challenge much more quickly. And the last thing I would say is that there needs to be some early thought about expert evidence. So which battlegrounds is a potential opposing creditor going to pick? And that leads into more commercial considerations and the very obvious good money after bad.
I mean, the final thought really is I suspect what we'll see happen over the next 24 to 36 months is the industry will move to start to reformulate plans in the same way that it did when CVA challenges happened a decade or so ago, and there will then be some early pioneers who will get their plans to the High Court first, where they've tried to readjust to get the balance right. I suspect that you will then see a slew of High Court cases in which the judges say, I'm having to deal with this on its own unique facts, and therefore what I say is confined to the facts of this particular case, but on this case I am satisfied that there's been proper thought given to the distribution of the restructuring benefits, and that this is fair, or indeed not as the case may be. And then what we really probably need is to turn the trilogy of cases into a quadrilogy, or tetralogy, or whatever the correct word is, and have another visit to the Court of Appeal for them to then say, as a matter of overarching principle, this is how one goes about the exercise of determining whether there has been a fair allocation of resources. Either that, or of course, the Petrofac goes to the Supreme Court and we get told that everything we said at the last hour is wrong. Waldorf, sorry. Yeah. Goes to the Supreme Court and we're told that everything we said at the last hour is wrong, that Virgin Active was right, and in fact you just get economic benefit. But assuming that that's an unlikely possibility, which of course you can't comment, I know, Stefan, as you're on one side of the argument, I think really we're probably ending phase 2 of restructuring plans and moving to phase 3, if I can put it that way. And so, to use a Marvel Cinematic Universe analogy, I think really, as you said earlier, Stefan, watch this space.
Interesting times ahead.
On that note, we have strayed on people's time for slightly longer than advertised, for which apologies. If anyone is still on the webinar and wants to pose a question to us, there is an ability to type a message in the chat box. So we'll wait on another 3 or 4 minutes or so in case any questions come flooding in. If not, and you'd much rather get on with your working day, then thank you for joining us. And if anybody has any questions that arise or they think of over the course of the next few days they want to debate, then please do feel free to drop an email to any one of us, and we'll do our best to answer them. In the meantime, Lisa Bricknell has said, do you think these, but then I'm afraid that might be a premature type. So do these principles have any application to CVAs? Very good question. I'm going to turn to my left and let you answer that one, Stefan, first shot.
I'm not sure they're going to have a direct application because a CVA is a different mechanism involving really majority rule. So there's no power of cross-class cram down. So the sort of issues that Zach was talking about in Adler, Thames Water and Petrofac, and which Mr. Justice Hildyard had to grapple with in Waldorf, are unlikely to come up in the same sort of way in a CVA challenge. Now, that's not to say that there wouldn't be scope for borrowing some of the learning which is happening in plan cases, and with appropriate adaptations, deploying that in a CVA case.
I certainly had a case at the start of 2024 where it involved a CVA where it was a similar approach to the treatment of certain classes of creditors. It was one of those landlord type cases where they were trying to bin off a problematic lease, and in return for being paid what was said to be a greater return than they would get under a formal insolvency process, we mounted an unfair prejudice challenge which then settled. And you can see the same sorts of considerations coming into play. So I agree entirely with Stefan that obviously we're not doing cross-class cram down, so it would be viewed through the other end of the telescope with a creditor positively coming along and saying this particular CVA may well have got 75% approval, but that's because the 75% who approved it were people who were being seen right by the CVA, and that this CVA unfairly prejudices the minority because our treatment under it is improper, because it doesn't regard the true consequences of the action. So you can see how you might map it on, and certainly you see some of the CVA cases forming the basis for some of the thinking, certainly in terms of the horizontal comparison.
Absolutely, yep.
In the Court of Appeal, in moving away from schemes in terms of the thinking. So I can see that they might have application, albeit it all depends, I think, on certainly those CVAs that could well be a restructuring plan by another guise, but where it's thought it might be possible to get the 75% approval in one class, they may well be relevant. For those where they're sort of, if I can put it this way, old-fashioned bog standard CVAs where you don't have lots of different classes of debt, and it's really more just about compromising claims to survive, then I suspect probably not. One follow-up question from Lisa is, how do you think a company would get around the situation that there are hundreds of creditors which need to be negotiated with? Can there be an explanation that it just isn't possible to do?
Well, thinking about plans, the reality is that you would have to group the creditors into classes, and so one would hope that even if you have a large number of individual creditors, it will be possible to group them into different classes. And then, to my mind, it's going to be a case of seeing how each class then interacts with the planned company. Certainly in my experience, thinking back to Fitness First, where some of the opposing creditors were landlords, some of the landlords had come together as a group and had instructed the same lawyers. The landlord I represented hadn't joined in with that and had gone down a slightly separate route. So what you wouldn't always expect if you were for the planned company is to have the creditors coalescing and working effectively together. So it's a problem which in practical terms may not often come to pass, I would have thought.
I mean, you have certain obvious classes of creditors that you can expect to be proactive. I mean, HMRC are a clear and obvious example in a category of their own, even if they're classed together with others in terms of economic interest. You know that they are going to be forming a view of a plan, and early engagement with them is always going to be a sensible thing to do. And one can presumably get a steer from, at some point they'll have to take a formal position, much as they did after the gas and the Naismith cases, where they came out and said, these are the sorts of things we're looking for from a plan, this is the circumstances in which we'd be happy to be crammed down or would vote in favour, as they did, I think, in some of the plans. In fact, I think they didn't finish Thursday, didn't they?
Yeah.
There will be others, Stefan says, like large landlords who, again, you might expect them to make a lot of noise. You can see that certain institutional lenders, for example, may just choose not to engage in the arena in plans. But I mean, each case is going to develop on a case-by-case basis, and so you can see really what you're doing, I suppose, is preempting challenges, aren't you, as much best you can, thinking about the sorts of creditors who might well object, and then thinking how you can rationalise what you propose to do in respect of them. I mean, it seems to me that really, in very, very crude terms, we've had 2 rounds of the court basically saying, when it comes to plans, don't take the mickey, and ensure that what you do is something that's objectively reasonable, and there's a lot of wiggle room within that. But the cases we've been looking at today are examples where actually there has been too much loaded onto the existing secured creditors in terms of sharing of the benefit, and not enough consideration for unsecured creditors. And it will take time to adjust where the line is, or it's probably not a line, it's a spectrum, where the reasonable range is. But we will get a feel instinctively eventually, I think, for what clearly falls outside that line, what's well within it, and then the interesting question for the lawyers is those cases that somewhere in between the two.
Absolutely. I mean, affordability is likely to be a key feature, certainly in the sort of plans such as Waldorf, but in other types of plans it might be some other factor which is really going to be the driving consideration for what is going to be fair. But as we've said, it's interesting times ahead.
Well, I think we're going to now make the reasonable working assumption that everyone who wanted to ask a question now has. And on that basis, as I say, thank you everyone who's attended and those who are still remaining on. And if there are any questions, then do feel free to email us. Keep your eyes out in your email inboxes for details of the next webinar in our series, which will be coming soon. We're planning to roll out webinars on insolvency and restructuring topics over the course of the autumn, and so there's more to be seen in due course.